Assemblymember Williams, please join us. You have item 14, AB 967, and item 15, AB 968. We'll give a minute for the room to clear. Then you'll be only talking to us.
Yes. Madam Chair, members, before I begin my presentation on 967, I would like to accept the committee amendments and request to change the intent language under staff comments number 3 of the committee analysis. I'd like to make the amendment state the following. Instead, it is the intent of the legislature that the standards of discipline adopted and implemented by institutions be fair, objective, consistent, and for the most egregious violations of the institution's sexual assault policies include a minimum of 2 years suspension up to a maximum of expulsion. AB 967 will now require California's public post-secondary systems, as well as each independent post-secondary institution, to adopt and implement a consistent standard of discipline for students found responsible for campus sexual assault. Additionally, this bill would also require campuses to publicly report and disclose campus adjudication outcomes for sexual assault offenses. Members, I began this while I was chair of higher education. We asked institutions for information, and I still probably only have information for 5 of the nearly 130 institutions in the state. This data will be essential to identifying trends in order to determine where to allocate resources in addressing the problem of campus sexual assault. In addition, greater transparency of this data sends a strong message to the students and general public that the universities are responding to the cases. With that, I'll go to my witnesses.
Thank you very much. In support of the bill.
Good morning, Madam Chair, members of the committee. My name is Meredith Turner, and I'm here on behalf of the Cal State Student Association, which represents the 460,000 students at the Cal State University. And I just want to say thank you to Assemblymember Williams for continuing to champion the issue of sexual assault prevention on our campuses, and we are very much in support of this bill. Thank you.
In support?
Good morning. My name is Patrick Dorsey. I'm also a member of the CSSA, and I'm also a student at Sacramento State University, and I support this bill as well.
Thank you.
Good morning. My name is Melissa Bardo. I am a student at Sacramento State and the Executive Vice President of Associated Students, which represents more than 29,000 students at our school, in support of this bill. Thank you.
Thank you very much.
Good morning. Andrew Martinez, California State University System. We had a support of amended position on this measure. We're appreciative of the work of the committee and the author to come to agreement on amendments. With me today is our Title IX officer, System-wide Officer Pamela Thompson.
Good morning.
Available to answer any questions if needed.
Okay, so you're in support of the bill?
I believe so. We'll wait till the amendments are in print, but yes.
Okay, all right.
The CSU is already, through policy, requiring the campuses to make the kinds of reports that this bill would require, so it makes sense to collect that data.
Okay, thank you.
Good morning, Madam Chair and members. Jason Murphy on behalf, excuse me, of the University of California. We have not taken a position on this bill yet. However, we do sincerely appreciate the great work of the committee as well as the willingness of the author to compromise. We think it's moving in certainly a positive direction. We think we'll get there to support. We're not there yet until we have a final opportunity to review the amendments.
Thank you.
Good morning, Veronica Villalobos with the Independent Colleges Association. We too appreciate the author's time and willingness to work with the segments. We had very strong concerns with the requirement of a minimum sanction in this context. We are willing to obviously look at the language and hope if it is intent language that it not be tied to the eligibility of financial aid for institutions. Again, thank you for your work on this issue. Thank you.
Thank you. In support of the bill.
Justin Selnick on behalf of the California Community Colleges Chancellor's Office, and we don't have a position today simply because we're still looking at the proposed amendments, but we see them as a positive step, so we'll keep working on it.
Okay, thank you.
Lizette Everett on behalf of the Community College League of California. In a similar note, we'll be taking these amendments to our board, but feel that the amendments are actually very positive and move all of our colleges in a very good direction. So thank you.
Okay, all right, thank you very much. Any opposition to the bill? We didn't receive any. Any questions or comments from members? The bill has been moved. Would you like to close?
Respectfully ask for your aye vote.
Very good. Okay. How come that was so easy? Okay.
Do pass as amended to appropriations. Lou.
Aye.
Lou, aye. Runner.
Aye.
Runner, aye. Block. Block, aye. Hancock. Leyva. Aye. Leyva, aye. Mendoza. Monning. Aye. Monning, aye. Pan. Vidak. Aye. Vidak, aye. That's 6.
You have 6 votes, sufficient for passage. We'll keep the roll open for our absent members. You also have item 15, AB 968.
Thank you. 968 is the third and final bill in our package on campus sexual assault. It establishes a standard notation across all of California's higher education segments for academic transcripts which will indicate on a student's transcript when the student is ineligible to re-enroll due to suspension or expulsion, and the period of time the student is ineligible to re-enroll. Currently, there is no standard for noting on an academic transcript when a student is suspended or expelled for violating a university's code of conduct, which includes campus sexual assault. And senators, it's alarming that if a campus adjudicatory procedure finds someone culpable for such a matter and then there is no accountability on that individual, it will only be a deterrent and an encouragement for survivors to come forward if perpetrators are held accountable. For example, the community colleges only make a notation on student transcripts for academic dismissal or academic disqualification when the vast majority of the cases, community colleges, because they are open access, never expel people permanently. They do 5-year suspensions. For all those 5-year suspensions out there, there's no notation on their transcripts. So someone could go 2 BART stations down the road if they're kicked out of one community college and just enroll in another one. The inconsistency between the post-secondary education segments demonstrates the need to establish a standard that provides more clarity and more information for universities when they consider an applicant for their campus. We did have a witness with CalCASA, but they had to leave.
Okay. All right. Anyone in support of the bill?
Andrew Martinez, California State University. We are in support of the bill. This is consistent with our current practice. Thank you.
Thank you.
Good morning, Madam Chair and members. Jason Murphy on behalf of the University of California. Pleased to be here today in support of the bill.
Thank you.
Meredith Turner with CSSA. And I think what we like most about this bill is that no matter what institution a student attends, that if he or she is expelled or suspended and tries to transfer to another university, that university can make a decision that's in the best interest of their own students and their student safety and determine whether that student should be admitted to that institution or not, dependent upon what they were suspended or expelled for. So thank you again to Senator Williams, and we're in support of the bill.
Pam Thomason from CSU Chancellor's Office supporting the bill, and this is one more example of how California is being a leader in this area.
Great. Okay. Thank you very much. Any others in support of the bill? Is there any opposition to the bill? The committee did not receive anything in writing. Are there any questions or comments? Senator Pan.
Oh, thank you. Thank you very much, Williams. A question in terms of the notation on the transcripts. Does the notation actually include the reason for the suspension, or is it just that they are suspension or expulsion? I understand. Or is it just that they've been suspended and expelled?
No, they would not. It would not have the reason on the transcript, so that everyone looks at the transcript would not see that. It would have the time that they are ineligible to re-enroll, and if this is especially important at the community college system because the current law requires a community college to have a hearing when a student that's been kicked out of one goes to another college, but they actually have no way to tell. So it's an illusionary law because it's not on any of the transcripts. They cannot right now tell, nor can they protect their folks at that community college if someone has been dismissed from a community college 10 miles away for rape. And so or any other offense. So in order to protect the sort of FERPA rights of the student, it only says that they are ineligible to enroll and for how long, and that student is required to disclose that at a hearing if they are ineligible to enroll, meaning a community college still has the option to enroll that person, but they have to have a hearing, and it would have to be disclosed at that hearing.
Okay, so you have a notation on the transcript that doesn't explain the reason. Is the school, and I know you mentioned FERPA, is the school which the student attended, are they going to disclose the reason? I guess my concern is this, is that I know that the reason you're doing this bill is that we don't, that I believe is that because certainly, you know, we don't want someone who might have committed sexual assault, rape, so forth, and when they're being suspended, to then just be able to transfer to another school and no one knows about it, right? But the notation is just that they got suspended and expelled, and probably for some not so good reason. You usually don't get randomly suspended or expelled. But I am concerned that basically what we've done is that, and we can talk about other potential reasons why they've been suspended or expelled, but I'm just a little concerned about, I'm concerned about that now you have a mark on the record and there's no explanation. I guess, you know, certainly the interviewer could go ask the student, why were you? I saw this on the transcript and so forth. But it's, I'm also concerned about whether that also, you know, is going to disadvantage, you know, certain groups or something. I know there's a big literature around racial disparities in terms of suspensions in public schools. I realize it's very different from higher ed, but you know, there's also, is there an issue, is it going to be an issue in higher ed where people have marks on their transcripts but without explanation, and that, is that going to, you know, we're going to generate an issue in that regard. So I just want to be a little cautious about, I agree with you that people should know if someone's committed a, you know, a serious crime like sexual assault, that they don't have a way they can evade that and sort of transfer to another school, and the other school doesn't know and so forth. But I also want to be sure that in the process of doing that, especially since this is not specific, that we're going to then create a system where basically it's easier to say if you're on the admissions committee, oh, something's on the transcript, we'll just not admit that student or allow that student to transfer, and then just simply not even ask any questions and move on and not even consider that student. And it could be for other reasons that may be more either benign or other reasons that perhaps they should be heard out. So I just wanted to touch on that issue.
You know, the law, the hearing process is a matter of current law and the previous bill that you already voted for. So the hearing process already requires a community college to assess if a student has been dismissed from another college and is ineligible to re-enroll at that other community college. It already requires the second community college to have a hearing of whether to admit that person and not admit them automatically, right? This simply is a mechanism to make sure that they can actually comply with that law. Without a notation of any kind on the transcript, they would not be able to do that. I will tell you why these segments resist putting a specific marker, and that is because it's not a criminal procedure, and so sometimes there will be a dismissal for something that is rape, but they won't call it that in the dismissal procedure in order to be able to get a successful finding of culpability. And so it is, again, it is the responsibility of the hearing process and the student, if they want to get admitted, they have to disclose this. If they're not willing to disclose it, there obviously would be good grounds for the college to not admit them. In these bills and in this process, this still provides for the individual discretion of that college to make the call whether to admit them or not. But the importance is they have the mechanism to protect folks on those campus when someone could have been just found culpable 2 months before at an adjacent campus.
So just one other question then. So, because you mentioned about the hearing so is the college required to have that hearing, or could they simply say, we saw that on the transcript, we don't even want to consider having the person transfer? In other words, they would never have an opportunity to explain what that was about.
That is up to the college. I mean, again, we have a system, community college system that does provide great degrees of local control, and there's a reason for that. I don't always like it, but that's the way it is. So they do have the discretion to not admit that student. I mean, frankly, if they're not eligible to re-enroll at the community college 10 miles down the way, and that's recent, then that is probably because of either cheating or significant issue like sexual assault or assault. And so that is an important issue. There have been actually some high-profile cases of situations where students are now, because the system doesn't work well, are having to go to school with someone who knifed them, right? So that there are other issues besides just sexual assault. We need this system of campus adjudication procedures to work better, and a notation is a pretty important part of that.
Well, okay. Well, thank you. I think the lack of specificity may raise some concerns, but I appreciate your response. Thank you.
Okay. Any other comments or questions? Senator Block?
Yeah, thank you. I'll be supporting this bill, but as a practical matter, having worked at community colleges for a while, unlike the universities where a student will go and will oftentimes reside there and maybe is away from home and wants to stay at the institution, with a community college where students are sometimes taking one class, a couple of classes, when something like this arises, if they're accused of some very bad act, they'll leave. I mean, there won't ever be an adjudication by the campus because the student will just withdraw. He or she will quit. There'll be a criminal prosecution, perhaps, which begs the question, should our campuses do criminal searches? Because that's how they'll really find out if they're bringing in a rapist or someone who stabbed somebody else. I'll support the bill because it certainly, I don't think it does harm, but I'm not sure it really does a lot, really, because you don't see a lot of these hearings at community colleges because students just leave.
I'm sure that does happen. We, in our roundtable process, did ask community colleges, and some community colleges, including my own local one, SBCC, did present data on the number of 5-year suspensions. They do have a number of 5-year suspensions. This is one of the violations of the Code of Conduct that this happens often enough that it raises sort of to the high on the bar among all the offenses that are out there. And we also had representatives from the Ventura Community College District sort of put in the same sort of things, and that's 3 campuses. So that's at least 4 campuses. This is a common thing that happens on it. And I think your question does beg the question about the relationship with the criminal procedure that I would want to answer as my close, perhaps, to not take any more time. Why do we do this through the campus procedure? Why isn't the criminal justice system the place? And why would we even be asking campuses where they don't even live on campus to do this? And the reality is because there's no other way to provide this accountability in society. I mean, the sad fact is nearly 0% of rapes end in any kind of accountability for the perpetrator. And how can we provide in our society a deterrence when nearly 0% end in any kind of accountability? And the answer is that because 1 in 5 women will experience sexual assault during their college career, that means a large percentage of society's total rapes happen during that 4 years or 6 years that you are in college. That means that we have an additional tool, which is the campus adjudication procedure, the code of conduct that every student is required to sign if they want to come. We have that tool. We should use it. We should use it better because it is the most realistic way that we can provide a deterrence and the most realistic way that we can assure survivors that if they're going to be brave enough to come forward, that there may be a chance of justice.
Okay. Any other? The bill has been, Senator Pan, you just raised another question that Senator Pan's had.
Sorry. Well, actually, I just want to, I'll vote for the bill today. I still have some concerns. It'd be helpful, actually, I don't know whether you are, if we have data on the reasons people get suspended or expelled. Again, I just want to be sure we're not casting too broad of a net, that we're going to, if someone, let's say, gets suspended or expelled for civil disobedience, and now they have a mark on their record, which then they never get a chance to explain, that would be, very concerning to me. So I think being able to have that data would be very helpful. I certainly support what you're trying to do in terms of being sure we protect people on campus, but I think we just want to be sure we're not casting too broad on that. Thank you.
Okay, I know for me, I see this as trying to set a standard of behavior between post-secondary institutions that if this is a marker on your transcript, it's up to the receiving institution to decide whether or not they want to pursue this in order to let you in the college or not. So, it's that flexible. So for me, I have a do pass for this bill. The bill has been moved. Call the roll.
Do pass to appropriations. Lou?
Aye.
Lou, aye. Runner?
Aye.
Runner, aye. Block?
Aye.
Block, aye. Hancock? Leyva? Aye. Leyva, aye. Mendoza? Aye. Mendoza, aye. Monning? Aye. Monning, aye. Pan?
Aye.
Pan, aye. Vidak?
Aye.
Vidak, aye.
That's 8 votes. We'll keep the roll open for our absent member. It's sufficient for passage.
Thank you, Senators.
Thank you very much. Assemblymember Garcia? You have item 8, AB 302, followed by Assemblymember Joan Sawyer.
Good morning.
Morning. It's still morning.
Yes,
Hurry up.
Okay, I'll hurry up. I want to accept the proposed amendments to make the CP a 60-day timeframe. Assembly Bill 302 would specify that schools with one or more lactating students shall provide these students with access to a private, secure room to deal with any needs associated with breastfeeding or expressing milk. AB 302 would also require schools to allow lactating students to bring a breast pump to school and store express milk, and it would require schools to provide these students with reasonable break time or time away from the classroom to accommodate their lactation schedules. This bill leaves flexibility for schools to find the solution that best meets the mothers' and schools' needs, and existing space can be utilized. This bill also helps remove barriers and give more choices for young moms to continue with their education if they choose to breastfeed their infants. With me today to testify is Angelica Areola Sandoval, a Fresno area graduate from Medicine High School, and Angelica Salceda with the ACLU of Northern California. I respectfully ask for an aye vote.
Okay, in support of the bill, please.
Good morning, Chair and members. My name is Angelica Salceda. I'm a staff attorney with ACLU of Northern California and the author of a recent report we published that examined and identified a number of educational barriers that pregnant and parenting students face. While the findings of our report have statewide implications, the research was focused on the Central Valley, a region home to 6 of the 10 counties with the highest teen birth rates in the state. It's also an area that is afflicted with a high poverty rate, a number of public health barriers such as physician shortage and a lack of quality sex education that compound the challenges facing pregnant and parenting students and make it all that more imperative that schools take action to reduce institutional barriers and adopt programs to support these students' academic success. After reviewing school district policies, having direct discussions with young parents, and surveying over 150 pregnant and parenting students, we found that schools were not providing lactating students with appropriate accommodations to continue breastfeeding. In effect, some students were making educational decisions based on where they could breastfeed or express milk. For example, we worked with an honor student from Reedley, California, who was told by her high school counselor that if she wanted to pump and stay in school, then she should enroll in continuation school or independent study. However, these alternatives locked her into remedial courses that did not provide her with a pathway towards higher education. We've also worked with students who have been told that if they want to pump, they can do so, but in a shared public restroom. This is completely unsanitary, and some students decide to stop pumping altogether when faced with that situation. It is undisputed that there are immediate and long-term health advantages of breastfeeding for infants and mothers. It can reduce acute and chronic health and costly conditions such as ear infections, asthma, risk of diabetes, obesity, and rates of breast cancer in mothers. By supporting these young moms in their decisions to breastfeed, they will have fewer health problems that will help keep them in school and help them succeed with their academic and personal goals. AB 302 would ensure that this unique population of students have access to a private, secure location to be able to breastfeed or pump. This is an accommodation that we already provide for our employees, and it's time that we also provide this to our students. I respectfully urge your aye vote.
Thank you very much. Others in support?
Good morning, Chair and members. My name is Angelica Ariela Sandoval, and I'm 18 years old. I recently graduated from Edison High School in Fresno. I will be attending Fresno State this August. I am also the proud mother of my son, Jeremiah, who is 2 years old. Today, I want to share my experience as a parenting student and the importance of providing accommodations at school for students who want to breastfeed or express milk. I got pregnant when I was a sophomore in high school, but I didn't find out until I was 5 months into my pregnancy. When I finally went to a doctor, he told me I had a complicated pregnancy and recommended that I stay home for the rest of pregnancy. Rather than provide homebound instruction, my school placed me in independent study, and I wasn't able to continue taking any AP classes because they didn't offer them through independent study. Instead, they made me take classes that I had already taken because there were no other higher level courses available. Once I had my son, I wanted to go back to Edison, which was my regular high school. Edison did not offer childcare, but they did have the AP classes that I wanted to take, so I was determined to go back to that school. I also wanted to breastfeed my son, which I was able to do for only a month while I was on independent study, but I didn't know how this would work out once I went back to Edison. The stress of trying to keep up with my credits, of fighting with my counselors so that I could enroll in AP courses and honor courses, of juggling family responsibilities and figuring out who would take care of my son all affected my ability to produce milk. I was only able to breastfeed him for a month. Pregnant and parenting students also face a number of challenges and barriers that push many of them out of their regular high schools or push them into programs that are not challenging. This happened to me. I don't remember anyone at school ever giving me any information or providing support on how I could breastfeed and still stay in school. Many young moms like myself are forced to pump into unsanitary locations like public restrooms, but a restroom is no place to breastfeed or to be preparing the food for your child. Some students have to pump at all hours of the night and early in the morning before school so that they can have milk for their babies because they're not allowed to pump at school or because there's no place to do so there. Even though I only breastfed my son for a month, I know it can be extremely painful when you cannot breastfeed or pump. And having to pump in a dirty restroom while struggling to keep up with your credits and classes only adds more stress. Students shouldn't have to choose between staying at their regular school and going on independent study just to be able to breastfeed or pump. This is why AB 302 is so important. It makes sure that students who want to pump at school have access to a private, secure place to do so and a place to store the milk and can take their breast pumps to school. For these reasons, I respectfully urge the aye vote.
Thank you very much. Yes, sir.
Madam Chair, members, Dennis Garcia on behalf of the California Latinas for Reproductive Justice, co-sponsors of this bill, ask for your support.
Thank you. Others in support of the bill, please identify.
All right. Adonai Mack with the Association of California School Administrators, also in support.
Okay, thank you.
Erica Hoffman on behalf of the California School Boards Association. We appreciate the work of the author and her staff and the amendments that you've taken over time, and we do support the measure.
Okay, thank you very much. Any others in support of the bill? Is there opposition to the bill? The committee didn't receive anything in writing. Are there any questions from members? The bill has been moved. Closing remarks, Assembly Member.
Just want to thank Angelica for sharing her story with us, and I respectfully ask for an aye vote.
Thank you very much. We'll call the roll.
Do pass as amended to appropriations. Blue.
Aye.
Blue, aye. Runner.
No.
Runner, no. Block. Hancock. Leyva. Aye. Leyva, aye. Mendoza. Aye. Mendoza, aye. Monning. Aye. Monning, aye. Pan. Vidak.
Aye.
Vidak, aye.
5-1. 5-1, sufficient for passage. We'll keep the roll open for our absent members. Thank you very much.